where the Constitution requires Parliament to determine a matter in the first instance as part of its constitutional mandate, Parliament will have the discretion and the power to regulate its own affairs, and the court will be slow to interfere with the exercise of that discretion. Reference in this decision to counter assembly can also be referenced to the National Assembly. Flowing from the decisions, where the Constitution commits a process to another arm of government, the court should allow that process to complete, that arm of government to complete its process before the court exercises its judicial review jurisdiction over the matter to determine whether what was said to be done under the authority of the Constitution is inconsistent with or in contravention of the Constitution. Granted, this is the first time this country is experiencing an impeachment proceeding against the Deputy President. The petitioner has raised substantial questions, including violation of his right to a fair hearing, guaranteed by Article 50 sub-Article 1 and ring-fenced by Article 25 sub-Article C as a non-derogable right. The petitioner has also stated that the National Assembly, in passing the impeachment motion, considered extraneous matters other than the grounds raised in the impeachment motion. There is a further argument that constitutional imperatives on public participation were not complied with. The petitioner has given an example of Keio South constituency, serial number 95, to demonstrate this fact. According to the results for public participation in that constituency, the total number of people who participated was given as 43. Those who supported were 70. Those who did not support were 3. The percentage of those who supported was 162.79%, while the percentage of those who did not support was 6.98. It is implausible that an attendance of 43 people would produce 70 people in support, that's 162%, and 3 people in opposition. The petitioner has raised valid concerns. However, President bind this court so that although the Constitution grants the court jurisdiction to intervene where there is a threat to violate the Constitution or human rights and fundamental freedoms, the court must exercise restraint in matters of impeachment. This process has been committed to Parliament, which must be allowed to conclude its part. It is in our constitutional scheme, the people delegated the authority to state organs, including Parliament and the judiciary, to exercise the delegated authority only in accordance with the Constitution. Article 2 reminds everyone that the Constitution is supreme and binds all persons and state organs at both levels, while Article 3 places an obligation on every person to respect, uphold, and defend the Constitution. Article 10 sub-Article 1 also is clear that the national values and principles bind all state organs, public officers, and all persons whenever they discharge their mandate under the Constitution. National values and principles include transparency, accountability, the rule of law, and public participation, and as well as human rights. If a state organ fails to abide by any of the values and principles in the Constitution, the court exercises its mandate under Article 165 sub-Article 3 will come in and investigate whether anything said to have been done under the authority of the Constitution is inconsistent with or in contravention of the Constitution. It was in this respect the Supreme Court stated in a matter case that it would be reluctant to question parliamentary procedures as long as they did not breach the Constitution, and that the mandate of the court is restricted to the doctrine of separation of powers, to deciding on matters of individual rights and fundamental freedom. The Supreme Court then stated that in the exercise of the wide political powers, both the county, read National Assembly, and the Senate cannot act outside the confines of the Constitution and the law. For to do so would invariably invite the court's intervention. End of quote. In other words, the constitutional processes are to be are not about a dash to the finish line. They have constitutional imperatives that must be complied with, and if not, such infractions will not be out of reach of our Constitution. The timelines given in the Constitution are on the premise that its processes will be complied with, will comply with the constitutional requirements. Where there is an allegation that the constitutional imperatives have not been complied with, the affected person has recourse to the courts, and the courts will rise to the occasion and consider whether the state organ complied with the Constitution or the law. In that respect, ours is a constitution of hope and promise that institutions established under the Constitution will comply with its fundamental principles, and the promise that the Constitution is supreme and any act or omission in contravention of the Constitution is invalid. In other words, it does not matter how far the process may have gone, since no action is out of reach of our Constitution. This is what Lord Enning had in mind when he stated many years back that if an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order to set it aside. It is automatically null and void without more ado, though it is sometimes convenient to have the court declare it to be so. And every proceeding which is founded on it is also bad and incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. Article 2, Sub-Article 4 of our Constitution is not only the hope, but also the promise of our Constitution that we must abide by the constitutional dictates, for any act or omission in contravention of the Constitution is invalid. In that respect, I conclude this matter, and this is what I say. Having considered the application and argument by parties, the Constitution and the President, the prayer for grant of conservatory order is declined. However, in view of the issues raised in this petition, which also appear to relate to those in petition E522 of 2024, which has been certified for purpose of appointing a bench of an even number of judges to hear, I certify this petition as raising substantial questions of law and of public interest in terms of Article 165, Sub-Article 4 of the Constitution. This file is to be placed before the Honorable Chief Justice to consider appointing an uneven number of judges to hear this petition. Given the close proximity of the issues in this petition and those in petition E522, the Honorable Chief Justice may consider whether this petition may be heard by the same bench appointed to hear petition E522. I make no orders on costs. Thank you.